Hi, good evening. This is Attorney James Betzel calling. I know I just did one of these in Spanish, but I figured we've got a lot of English speakers out there as well. So I wanted to give an update on the latest rumor that seems to be going around about immigration. So we've seen in a few places now, and it routinely comes in through some of our client interviews that we do. Someone will ask, do I actually have to leave the United States to get my visa? Well, there's been a rumor floating around that you should never have to leave the United States in order to get your green card or your visa. And that's patently untrue. It's not that you should never need to leave the United States. There are many occasions where the only thing you can do is leave the United States to go to your interview at the consulate in your home country. So for the English speakers out there, here is the video I just did in Spanish, but in English, because it's quick enough to do. So let's go over some of the reasons that you might not have to leave the United States in order to get your green card or to obtain your status. First of all, and one of our favorites to use is 245A. All right, so 245A, INA 245A is the section of law that says if you, oh, that's in Spanish. Hold on, we're going to change that. It's if you had a legal entry to the United States, and that was the last time you entered. The last time you entered, you had a legal entry, and now someone here has, they can file for a petition for you. They can file it for your visa. So it could be a spouse or a child, not a child, but a son or daughter who's now over 21 years old, or some other program. If your last entry to the United States was legally, then you can usually adjust your status here without leaving to go to your home country. Okay, so that's probably exception number one. Now, I see I've got a few people watching already. If you have any questions, please feel free to throw those into the comments. I'm watching, like, while this is live, I can probably answer a few questions there, different situations as well. But the very first one that we want to talk about here is that legal entry. So if your last entry to the U.S. was legal, perhaps you don't have to leave the United States to get your green card. All right, so we're addressing a recent rumor, and the rumor is that you never have to leave the U.S. to get your green card. That's certainly not true. I'm an attorney. I'm an immigration attorney, and I've been so for 12 years. I know what I'm talking about. We've seen a myriad of situations: immigration court, removal defense, family petitions, victims petitions, and there's certain situations where at the end, in order to get your green card, you just have to go to your home consulate to do that. But we're covering here the very exceptions, the exceptions that are sometimes rare. And the first one we just talked about is under Program 245A, if you have a legal entry. Now, what if somebody filed a petition for you on or before, let's see, the date is April 30th of 2001. Now, keep in mind, there's other qualifications to this one, but if somebody entered, if somebody filed a petition for you on or before April 30th of 2001, and we're talking, it could be a family petition, and that petition maybe is now current, or they filed that petition for you, and you were here as of like December, I think it was December 20th of 2000 as well. There's, like I said, there's other requirements. But if you have that 245I petition, and either that one's current or your spouse or family member can petition for you now here, well, then you could very possibly adjust your status here without leaving the United States. That's another exemption. Now, there's plenty of these cases out there still. We still see those on a somewhat routine basis. And thanks to something called grandfathering, even if you can't adjust on that petition, but now somebody else, like your spouse, wants to file for you, as long as somebody had filed a petition for you on or before that date, it counts. And it counts if it's a family petition, if it's an employment petition, or even if it's a labor certification. If it was filed on or before that date, you could be in. So definitely worth finding out more details in that situation. Now, we always have to be aware of something called the grounds of inadmissibility under INA 212. And that means that even if you were allowed to adjust here based on either 245A 245A because of a legal entry, or 245I because somebody filed a petition for you on or before that date. If you're still inadmissible because of a criminal reason or some other reason, you may need a waiver and you may not be able to take advantage of adjusting status here. So you always got to be aware of what the grounds of inadmissibility are that might apply to you. All right, let's go on to the next one. Sorry, I'm kind of doing this in real time here. There is a program called VAWA, and it stands for the Violence Against Women's Act. And I know what you're thinking. You're probably thinking, well, that's not fair. It should apply to men too. And thank you to the Supreme Court, it does. Okay, it applies equally to men and women. If you're the victim of domestic violence, you can file for, it's on form I-360. You can get what's called a VAWA petition. It's a self-petition where instead of your spouse petitioning for you, you can petition for yourself. And once you have that approved, you can also file for adjustment of status. Many times you'll file those both at the same time, especially if it's a good, strong case. So if you were the victim of domestic violence and your spouse is a resident or citizen here in the United States, you would be able to adjust your status and get your green card here in the US without leaving. Again, doesn't apply to everyone. You got to sort of prove the facts of that case. We've done a number of those cases. We've done many of those cases and won. So very good cases typically. And yeah, they can all adjust status here without leaving, because a lot of times, especially in those situations, they may have kids or other family or employment, or even to be able to escape the domestic violence, they need that ability to get their green card here without the oppression of their spouse. So that's another exception. If you have a VAWA petition that's been approved, you can adjust your status, get your green card here in the US. Here's a couple others. If you have a U visa or T visa, not just that you've gone through the process in the waiting period and getting your work permits. No, once you finally get that U visa and you've been here for 3 years, then you can actually go ahead and file for adjustment of status to get your green card in the United States. Same case for a T visa. As soon as your eligibility time for that happens, which could be a year, could be 3 years, since you've had the T visa, there is a possibility to adjust status here. All right, we're starting to get some comments. Let's take a look at the comments. It doesn't really interrupt my flow. Let's see here. Buen día, doctor. Esta pregunta es un poco diferente, pero quiero preguntarle, aplico para un perdón con antes. Okay. Yeah, that's a question that's not on topic. It's in Spanish. I did my video there. If you want to go leave that comment, Andrea Hernández, si tú quieres poner el comentario con el otro video que acaba de hacer en español, le voy a contestar también. Después voy a revisar aquí y contestarle, pero este video está en inglés. So this video is in English. Sorry for that. Want to make sure everyone who's watching can understand. We did a separate one on this. I'll answer the comments later if they're off topic. Another reason that someone can get their papers here in the United States without having to leave, it's a little complicated, but it's called, oh, you know what? I got it. We'll just write military parole in place. It's called military parole. So what it means is you have an immediate family member, spouse, child, parent, brother or sister, who's a member of the U.S. Armed Forces, and you have a way where you could get your green card here, but for not having a legal entry. So if you would be able to get your green card because if you did have a legal entry, but you can't, but you have one of these members of your family in the military, you can apply for military parole in place. And what that does is it's a legal fiction. And what legal fiction means, it legally creates something that didn't really happen, right? It gives you that legal entry that you didn't have. So military parole in place is very useful. We've used it in many situations to help people do their adjustment of status here in the United States without having to leave. What's another situation? If you already have, better hide that because I got to edit it. If you already have asylum, if you've been granted asylum either by USCIS or by the immigration court, you have refugee status for 1 year, and then you can apply for your green card here in the United States. You don't do that at your consulate, at the consulate at the foreign country. There is another program called registration. Now, registration is a good one. In fact, I want to pull up, got a little cheat sheet here that I use for explaining what is getting your green card through registry. Here we go. So this is a program that's available to individuals who entered the United States prior to January 1 of 1972. Okay. People who entered the United States prior to January 1 of 1972, even if it was without papers, entered unlawfully, illegally, however you want to say it. If you entered and you meet some other requirements, okay, we could do a whole video on this, but this is one where it actually forgives a lot of stuff. It forgives false claim to citizenship, voting. It forgives a lot of the criminal grounds of inadmissibility. But if you can qualify under registration, that is a reason that you can get your papers here in the United States. But again, you have that date. You got to be here prior to January 1 of 1972. So it's not going to apply to a whole lot of people anymore. But for those that it does apply to, it is fantastic. We've done that a few times now for clients, and it works very well to fix a lifetime of non-compliance with the immigration laws. Sometimes at no fault of the individual because they were told or they were given a birth certificate that wasn't really theirs. So really interesting cases. We got to do a whole video on that for sure. There's another program out there called NACARA. So this is available to some individuals from certain countries who filed asylum applications during a certain time period. But then once you have NACARA status, you can get your green card here in the United States. And here is one, which is really interesting. I've never had one of these cases. And I've had pretty much every other case type out there. But this one, a foundling. Now, you think of a foundling and you think of like maybe a little elf or, you know, some cute little animal, a foundling, like I found it. Well, it's not. It's actually a human being, right? So a child that is found in the United States and the parents cannot be found and there's no legal guardian who can be found. And essentially they're here and can't really prove one way or another. And we suppose that they may not be a U.S. citizen or resident, but they're going to give them the residency anyway because they qualify under this part of the law, which is called foundling. Very rare, very rare. Like I said, I've never seen one myself that we've handled, but I have heard and I've seen other attorneys who've handled those cases. So these are some examples of the different reasons that you maybe don't have to leave the country to get your green card. But by and large, there's many, 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 many cases where you do need to leave. And a typical case is your spouse comes to the United States. Let's say you're the U.S. citizen. Your spouse came without papers. They've been living here a while. They've never left. But you want to fix their green card, right? You want to get them their green cards. And you're not a member of the military and you don't and they don't qualify under one of these other, you know, legal entry or the 245I program or the U visa or the VAWA or military parole in place, asylum. None of these things apply to them. Or registration, the car filing. If none of those apply to them, then what we're going to be doing for you is filing what's called your family petition on the I-130. And then we're going to have to file a provisional waiver, sometimes called the 601A waiver. So that person, yes, at the end of getting the waiver approval and filing with the consulate, they will need to go outside the country to get their green card to come back. And outside of the exceptions I've raised here, there's no other ones. So the law is very, very specific about having to obtain the visa at the home consulate unless one of these exceptions applies. I want to thank everybody for their comments, participation today. Oh, Yadira Flores, good. And you're an English speaker as well, it looks like. Thank you for thumbs up in the comment. Looks like we're getting some traction on YouTube. Good to hear. I'm attorney James Betzold. I want to thank you for participating today. If you have more questions about your case, go ahead and throw those in the comments. You can also find more of our information, more information about us here on our webpage at visafeliz.com. It's also betzoldlaw.com. But we've got our Facebook Messenger thing there. We've got tons of free videos and information to help you in your immigration journey. thank you, and I hope you have a great night. Please, again, feel free to leave some comments. We'll get to those in due course. Thanks. Bye-bye.